canceled that one, the visitation center canceled that one, you know what I mean? So you have to be able to respond to that also.
You should have the statute you're referring to printed out and sitting next to you the whole trial anyway, but certainly you want to have it toward the end at least when you're doing your closing. It's best to state what's going on in your opening. A lot of times we don't. We just say, you know, these are the grounds, failed case plan, and go on from there. But if you can cite the statute in your opening and your closing and along the way, that's going to help. What I hate to hear is someone doesn't have it with them. And a judge will flat out ask you, well, what's the statute say about that? If the first phrase out of your mouth is, I think the statute says, as opposed to, well, if you'll follow along with me, idiot, judge, why you don't have your book in front of you, I will read it to you. It says line 3, you know, it's something you need to do. Because a lot of judges, they won't have their statute book pulled up on the computer. They won't. Some of them are computer phobic. I haven't figured that one out yet. Have your case law printed out, 4 sets. One for each parent's attorney, one for the other attorneys in the room, one for the state, one for the judge. Some judges are offended if you highlight, I don't understand that, but some are offended. Find out if your judge gets offended if you highlight the case law. But I'll tell you this, whether you highlight it or not, well, if you highlight it, make sure you highlight it for everybody, not just the judge, because that does offend people. I don't care personally whether it's highlighted or not, I'm going to read it. Give it to the judge sometime before you start your closing statement. If you take a break before closing, give it to everybody. Give it to everybody before you open. Just don't, oh, I forgot, Judge. I know I've only got a couple minutes left in closing, but here's my case law. Give it to them well before that. Give it to everybody well before that.
And if you really want to mess with people, highlight the wrong section.
That's right.
It's fun. Not for the judge, of course, just for the other attorneys.
If you're a parent's attorney, we're talking about timeline, remind them of a couple of things in your presentation. My humble opinion is you should have a sheet printed out that you hand the client in anticipation of a TPR trial when they enter into the case plan. At arraignment, when they consent, or when you meet them for the first time. And you should remind them that anger, outburst, and blaming others in the courtroom doesn't bode well. You should remind them that they need to take pictures of everything. And this is for trial, but if you give them this sheet in advance, look what you've done to help them prepare. You're not telling them to have an adversarial relationship in a case plan situation or a reunification situation, but keep records. Keep your AA records, your pay stubs, your 1099, your proof of gifts, call logs, emails, text messages, because I will tell you, on more than just a few occasions, parents will stand up and throw you under the bus and say, well, they never told me I needed any of that stuff. And then you got ineffective assistant counsel that comes, or ineffective assistance after that, and we got to go through that process. But if you give them this sheet of paper that tells all these things that they need to prove their case when the time comes, I promise you it will help you and it will help them when the time does come. As you prepare for trial, remind them again, or when the TPR petition gets filed, remind them again, I'm going to need this stuff. Well, they won't give me my rehab records, you know, okay. There are ways around that, but if you tell me in advance, I can get them. If they show up the day of trial and say, you know, I forgot all that stuff that you were supposed to give me, you don't have to worry about ineffective assistance of counsel. So be prepared, help them be prepared, have the sheet ready, give them the list before trial and when they sign the case plan.
So preliminary matters, there's a reason they're called preliminary, because they're supposed to be before the trial starts, right? Any motions you have, exhibits should be marked, right? They should be marked before trial starts, not during trial. That's kind of painful when we do that. Judicial notice, if you're going to use judicial notice, that should be, you should give notice well before trial. It's usually in the TPR petition. And the rule of sequestration. It's a good idea to explain that to your witnesses, because Anybody who's been in the courtroom more than once, they hear the rules being invoked, they just get up and leave. So they don't hear all of it, which is you're not allowed to talk to each other about the trial. So you go outside and you see grandma talking to the guardian ad litem or something, you're like, oh, no, you're not allowed to do that. So all of this stuff should be done preliminarily. Opening statement we kind of talked about. Did you have something else you wanted to?
I was just going to say, the rule of sequestration for a laminated version and a Three Musketeers bar. Somebody tell me how the rule of sequestration applies to opening arguments. Just raise your hand and I'll hand it to you. How does the rule of sequestration apply to opening? Anybody in my courtroom knows. How does it apply to opening? It doesn't. Very good. Because why? Anybody know why? It's not evidence. That's right. There you go. And so I'll give you more since y'all shared that answer.
Okay, order of witnesses. Don't call 12 people to say the same thing. And don't forget to call the parents as witnesses. The judge is going to ask how many witnesses you have, right? How long each witness is likely to take. I had a judge one time tell an attorney I was working with, do not bring 12 witnesses to tell me the same thing. Here's what I'm going to do. I'm going to swear all your witnesses in at the same time, and I'm going to ask them the question, because you're asking them the same question, they're going to answer the same way. It'll shorten the trial. So be honest with the judge when the judge says, how many witnesses do you have, and how long is it going to take? Everybody's like, yeah, this TPR, 2 hours. Not true. I know some of you can't say hello in 2 hours. So, because I've worked with some of you. So be honest about the timing of the case and how long your witnesses are going to take. And if you've prepared them, it's going to be shorter, right? You don't have the case manager going through their, that big cart, that big blue cart that they always have with them with 17 files in it. And you ask them a question, they start going through all of them. That's painful. It shouldn't happen.
The predicate to get the case plan in through a caseworker. Roughly how many questions you think would be involved? Somebody just give me a ballpark. Three? Tell me what some of the three would be. Did you draft the case plan? What if it's 3 years down the road that caseworker's not there anymore?
Is this record generated by somebody in the ordinary course of business?
Yes. And then what else? What are the other? There were a couple more. You said there are three?
Is it kept and maintained in the ordinary course?
Right.
We have another answer on this side, too.
In the back. All the way in the back. Yes. Are you the custodian of records? Is a case worker a custodian of records? Okay, so I guess I should have prefaced that with, who are we calling? Who are we calling to get the case plan in? The custodian of records, is that how you do it? So you got a custodian of records that you're calling. You have a caseworker who is working with them, because the ultimate question is you want to know, did they finish the case plan, right? What else?
It's filed, so can't you admit it pursuant to judicial notice?
Perhaps, if you remembered to do that. Or what if you said, I'd like the judge to take judicial notice right now, right this second, of the case plan? Does that work in y'all's courtroom? No, usually not. How about this? What if I call the parent? I'm holding Exhibit 1. It purports to be the case plan. Is that your signature? Yep. Your Honor, we'd like you to admit this Exhibit 1 as the case plan. Will that work? Sure it will. Great answers, though. But if you call the parent first, all you have to do is ask for is that your signature? Now, if they say, I don't recall, well, you may have to do something else, but hopefully they won't be that obtuse.
So
But all of that will work. All of that will work.
Yes, case manager, judicial notice, parent, there are various ways to get that in. Now, the parents are going to object to parts of the case plan. Anybody tell me why they object to certain parts of the case plan? Very good. I'm going to throw the candy at you. I won't throw
There are too many at once.
I won't throw the wine because it's glass, but do we have Val back there? Can you help us with the candy? Would you mind? Yeah, or
Between the two of us.
the judge will bring it back
If
to you.
somebody shouts out an answer, give them some goodies.
So what's your
And if they don't
answer?
want chocolate, we have Starburst.
What's your answer? Objection, I object to the case plan coming in, being admitted into evidence because of hearsay. What's your answer? Bueller? It's part of the court file? That's 980326, exception to hearsay? Part of it is hearsay, right? What do you want out of the case plan? What are you trying to get the court to, the tasks, right? If they object, then one thing you can do is go through the tasks, right? Go through every task. Ask the case manager to say what it says. Ask the parent if they know what their case plan says. Of course, they always say no, but anyway.
Do you ever sit on the side of another attorney and they have a knee-jerk reaction to any hearsay? And have you ever had a judge say, why are you objecting to hearsay? They're saying good things about your client. I do it. I probably shouldn't, but I do it. I'm like, okay, I'll grant it. And then please don't say those good things about her client anymore, because she clearly doesn't want you to do that. Think about, in college, in law school, they teach you object to hearsay, object to hearsay. You even have the little scenario where you get points for how many times you object to hearsay in class. And so just think about what they're saying before you have that knee-jerk reaction. You'd be surprised.
And everything is hearsay, as Chris says. She's in the back of the room there. You only know your name because of hearsay, right? So honestly, you can say hearsay about anything.
All right, so what we're going to do now is I need 2 volunteers, and we're going to give you the answers in advance. I need an attorney, and I need a client. Well, actually, I need a business records custodian. Who wants to be the attorney? There we go. All right, I'm coming to you. Who wants to be the business records custodian? Anybody ever done that actually in court?
We
There
have
go
one in the
there.
back there.
All right.
You're the business records, yes.
I know.
That way nobody has to be voluntold. Right back here.
Say it out loud, real loud. Ask her your question on the business records.
Can I find my witness, please?
There she is.
Good afternoon. How are you doing today, ma'am?
I'm fine. I don't have my answer sheet yet, so let's assume I'm fine. Is that right?
Do you have something that would refresh your recollection?
Go ahead.
Good afternoon, ma'am. Can you please tell us what your occupation is?
I'm the records custodian for CRC.
Okay, I'd like to show you what's been previously marked as, say, Exhibit A for identification purposes. Okay, American Idol. Okay. What I'm showing you is this been previously marked as Exhibit A. Are we showing, is she looking at something? I was just,
You have really good eyesight, if you can see it from there.
Thank you. Yeah. Was this record kept in the normal course of business?
Yes.
Is it a regular business activity of your company to keep these records, ma'am?
Yes.
And who made these records?
The actual counselor, licensed mental health counselor, and such.
And does that matter? Does it matter that she didn't make the record?
Was it done at or near the time of the event in question?
Yes.
Okay, and are these, see, I've never seen this question before in this predicate. Are these exact duplicates of the original?
Certified and everything.
Certified and everything, okay.
Isn't that last one, Taryn? Very good. Both of you. And you both get to keep your sheets. They're laminated. That's free. The reason that last one is on there because there are certain attorneys who will object as best record. It's not an original. It came off a computer system, and that last question comes from the mortgage debacle. There were cases that were overturned because that question was not asked. Don't know if it was original or not. And as you well know, thousands and thousands of fraud cases flipped all of that on its head because that one question wasn't asked. Is this an actual duplicate of the original? Very good.
Excellent.
You're in the running for the wine, by the way.
Very- We're We're going to have an arm wrestle, I think, after. I don't know. Okay, so I went backwards a little bit in the PowerPoint, but we wanted to talk a little bit about closing arguments, which are really important. It helps to frame your case. What I used to do when I did trial work, it's been a while, is I would do an order, a final order, and those were the findings I wanted the judge to make, and that included all the findings, so that would be my closing argument as well. So I didn't read it because it's painful to watch somebody read. Some of our practice tips in here are about having questions for witnesses and things of that nature. I personally cannot work from written questions when I'm talking to a witness. My focus is on the witness, and so I ask questions, and it seems more natural to me. What I do is highlight like a petition with what I want to get from each witness, and that goes in the folder that I have for that witness. My trial notebook had a folder for each witness that included the part of the petition that I wanted to get out of them, the case law, their CV, anything else that I needed regarding that witness. So the closing argument will flow from all of those things. If you have your order, you can always change your order, especially now. Back then, it was a chisel and a stone that I was doing my closing arguments on. So now with computers, it's a lot easier. Have it, and you can change it when you need to. Anything to add?
Never waive closing. Yes, ma'am.
I had to testify regarding the Litem and the TPR. I was not allowed to take any documentation of my own, such as timelines or dates. Why is that not, the guardian not allowed to take any, like, a sheet of paper with dates or when we entered the case or anything?
Well, there's an antiquated, absurd, bizarre rule that has never been changed by anybody that's in charge of that. I'm looking at this document right here, and it's my timeline. I would like to share that with y'all. It covers the 3 years that this case has been going on, so I have not memorized it. I'm terribly sorry. Who would? So, as the judge, ma'am, I need you to look at that, refresh your recollection, turn it over, and now tell me what it says. That is the dumbest thing ever as far as presenting evidence. However, they didn't put me in charge of that. So,
Who told you you
that's
couldn't?
why.
Who told you
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 can
couldn't
have it.
take it? No, so you're saying somebody told you you couldn't take it to the witness stand.
that's wrong.
Who told
you can
you?
have it. You can refresh your recollection with the back of my head. If it works, doesn't matter. It doesn't have to. Doesn't matter what it is.
Who told you couldn't take it to the witness stand with you? The judge, or the judge said that? Okay.
Some of us aren't that bright. or read Earhart. Yes, ma'am. Hold on. Let me bring you this so everybody can hear.
And our judge lets the guardian bring up the sheet, but she lets everyone else view it. So the parents' attorneys go up, and just so you know that the notes will be seen.
And the way the rule is supposed to work, they're not supposed, no one in the room is supposed to have this document until it's been testified about. Or it's gotten to the point where now you have a document, refresh your recollection. Someone will object and say, I want to see what she's refreshing her recollection with. The judge performs the rule execution properly, will say, when she's done, you may review it before you cross-examine her. Nobody's entitled to it, but we all have gotten to the point where, all right, look at it. If it'll shut somebody up, let them look at it. If they'll stop whining about it, who cares? But that's not how that's supposed to work. They're not supposed to get it until after it's been reviewed. However, very few judges stick to that particular rule.
When I train CAMs and volunteers and case managers and anybody else who's going to be a witness, I always tell them, make notes. It's a lot easier that way. It's easier for you. It's easier for everybody else. But you just got to be careful what you write, because they are going to take a look at it. So you can't say, like, that skanky mom missed another visit or something, you know. You can, but they're going to see it, and they'll cross-examine you on that. So you have to be careful what you write. But the other cure for that is, I would say, okay, how about if we just have it admitted into evidence and see what the objecting attorney says then, because usually they don't want that. But I'm sorry that happened. We'll have to talk about that. Call me. We'll straighten that out.
Okay, we talked about this briefly, but Kelly mentioned, don't have all your witnesses show up at 9 o'clock. I haven't had that experience a lot lately. When I was in criminal court, they have so many cases, they're all set for the same day. Half of them will enter a plea 50 or an hour into the morning, even though you've called them up on a calendar call 17 times before that. Everybody waits till the last minute. What really ticks people off is they get a subpoena for 9 o'clock and you call them in to testify for you at 2:30. So if you have a witness that's a little shaky about helping you, guess how shaky they're going to be at 2:30 when you told them to show up at 9. It's no big deal. Judges understand. I would rather wait 15 minutes for somebody than have everybody come at 9 and everybody pissed off by 2:30. Because the first witness is probably not going to be that short. Unless it's that mom that says, no, I didn't do the case plan, and yes, I told her to bite me.
Yep.
Unless it's that person.
And
So
then-
just remember, just set that schedule.
And then you rest. Plus, if something happens, you can call your witnesses and tell them they don't have to be there that day or whatever. Sometimes you get a Perry Mason moment, trial's over, you can. So this is about the separate folder for each witness. I like that. When you're, how many people in here have ever testified in court?
Oh, wow.
Okay. Was it a little unnerving the first time? Yeah.
Did your attorney tell you what to expect on cross?
I'll close my eyes. You can
Yeah.
answer.
Raise your hand if the attorney didn't say, hey, expect this attorney to cross you in the following fashion. Bad attorney. That's a bad attorney. You should always anticipate what you're going to get hit with when you're done. You know, they're going to say whatever they're going to say to you, but at least have some idea. At least tell your witness what do you think is going to happen on cross. It will alleviate a lot of angst and a lot of stress. It also cuts down on that blank stare and the no answer for 45 seconds, and then everybody thinks, well, he or she doesn't know what's going on. You just didn't anticipate it. You wanted to think through it. You wanted to give a proper answer, but some judges will say, well, why was she quiet for a minute? That's the good thing about appeal and the bad thing about appeals. There's no, the witness was searching for an answer for 3.5 minutes, so be prepared. Just be prepared.
Yeah, and it actually helps you prepare your case better, too, because if you're doing a mock cross with your witness, which you should be doing, you probably know the attorney a little bit better than your witness does, so you know how they're going to cross. This person right here, Judge Crawford, used to ask cross-examination questions that were like 3.5 minutes long. You're like, he's testifying while he's asking
The
questions.
answer was, yep, I agree.
Yeah. And so I would always tell my witnesses, wait till he finishes, unless I stand up and say, objection, Mr. Crawford's testifying. Can we swear him in? I would tell my witnesses, when he finishes his question, say, I'm sorry, I didn't understand. Could you please repeat it? And he would always say, nope, but I'll ask a different one.
We don't have court reporters, so nobody can read it back.
But if you're crossing your witness, you're going to get the weak spots too. You're going to figure out what they are, and then you bring them out on direct, so you steal the thunder, right?
I need an attorney who will be the examiner for email text messages. Who would like to do that? You do that? I need another attorney who will be the recipient.
We have
of
another
the
one right
email
here.
Text message. There we go. Raise your hand if you've had to get a snarky email into evidence. Anybody? Yeah? I think it's every case I've ever sat for. So somebody, especially if it's one parent against another parent. I can't remember the name of the case, but anyway, this gentleman was probably in his mid-20s. She was probably in her mid-60s. I kid you not.
Oh.
They were together. And is that about the right age?
Yeah.
He looked like, I kid you not, he looked like he could be on the front of any magazine. Man was handsome, built, articulate, and God bless her, she wasn't. So let's just leave it at that. They showed up the first day. They were madly in love. They wanted to keep their child, didn't want a TPR. Nobody wanted to separate them. They were madly in love. Second day, she shows up in an orange jumpsuit because she had been arrested. I'll let you tell the rest of the story, because I'm a male and I probably should.
It's actually reported in it's the MAP case. So I said, because the record's not going to show her manner of dress, so I said, that's an interesting outfit that you're wearing there, I'm in jail. And I said, what are you in jail for? And she said, because Robert came home last night and he wanted me to do something. And was jumping up and down trying to get me to do it. And so I clocked him in the head with a vase. And it was like much more colorful, which were being recorded, so I'm going to leave all those words out. And Judge Crawford was her attorney, and I was the department attorney. So he was just mortified. He's trying to get her to stop talking, because then she just went on and on and on about exactly what he wanted.
Very explicit.
Yes, it was very interesting. But he surrendered his rights, which he could have gotten his kid back. That kind of, she needed to be TPR'd, but, yep.
And so he gets up, he leaves, he's done, just surrendered his rights. Now she's sitting there in the jumpsuit after this horrific story, and she wants to keep going. And I'm like, it's not going to go well for you. You can cut the cord here, or we can go another day and see what happens. But I'm telling you, it's not going to work out well for you. And we trudged through it. She was not giving up. But it was an interesting scenario. So the moral to that story is sometimes it pays to talk to your witness. Because when she sat down in the jumpsuit, they had just walked her. I thought she was coming in the back door. Deputies didn't tell me. She came through the side door. The judge goes, let's go. So I'm trying to, what's going on? And as soon as I said, what's going on, she called her as a witness. So I didn't get a chance to hear the story. So I heard the oral presentation regarding the oral presentation from the stand. So I was taken aback just like everybody else in the room was.
And we found out what happened.
Yeah.
But yes, all at the same time. Okay, so.
We passed out the sheets, and we're going to do email website. I believe it's how it's styled. Email text message. Let me give you the microphone, so you tell us how to get in an email and a text message. Tell us the phrase. Sure. Unless you have it better.
No, I'm just like, I didn't know what I was talking to, so.
There's always a better way.
Yep.
There's always your style. These are not engraved in stone anywhere. These have come from Earhart. They've come from the Rules of Evidence. They've come from Texas Predicate Manual that I used 20 years ago when I was in the DA's office there. So this is just what I think, at a minimum, someone needs to do to get that information in. Or the best thing is, we stipulate. That's always the best. Right? Get somebody to stipulate.
I hand to you what is marked Exhibit Number 1. Do you I hand to you what is marked as Exhibit Number 1. Do you recognize this?
There you are. Do you recognize Exhibit Number 1?
I've got the same question she does.
Right. She says yes.
And what is it?
What is it?
Is exhibit number 1, email and text on the paper.
There you go.
And is this an exact duplicate of the contents of this email or text you found on the digital device, the cell phone? And what specific identifying information is contained on this device or email that justifies your conclusion that an individual sent this message?
See, I told you I like my own sentences.
It's identified by the phone number of the text and also the date, time, and the fact that I was sent the email following a telephone call.
And based on this identifying information, do you believe that who do you believe sent this email or text to you?
The parent.
Very good. Now, what kind of objections did you get that might very well be overcome? How do you know he sent it? So when you're going through how do you know this is from him or her, have them expand on that. Well, we were having this conversation on the phone shortly before that, and it carried over in the email. This is her pet name for me. Butthole, whatever, you know. She calls me that all the time. She included a picture of her dog up at the top. You know how some people have pictures in their email. Anything you can say that will identify the sender will get past that. And then let's say that the judge lets it in. What likely is he to say on the objection? This goes toward the right weight, not the admissibility. So it's all about, can you prove up that this person sent it? Because what's the cross going to be? What's the lame, the cross going to be? I say lame because it's usually pretty lame, because you don't have a choice. You know where they did it. What's some of the cross? How do you know? Well, I just told you. I'm not going to repeat it. I just told you. That's the first thing. I just told you. Well, isn't it possible that someone could have hijacked this email and sent it to you? Well, of course, anything's possible. Isn't it possible that there's somebody else in the house that doesn't want him to... You sent somebody over there, didn't you? Did you send somebody to that? You have access. Wait, you pulled up that email. Don't you know his password? No. He changed his password when he left me 3 years ago. I don't know his password. You'll get all of that. That's all coming.
And you're always going to get something too, like, do you save every text or every email? Why did you save that one? Like, it's somehow your fault that you have this information now, right? Did you show some sort of bias like that? Like, why did you save this? Well, because he was threatening my life or whatever it is in there. So yeah, you're going to get a lot of cross questions. Anything we didn't think about? Any other cross? Yes.
Can I ask Judge Crawford, have you had to address an objection regarding the admissibility of a text message based on the rule of completeness?
Yes. Where's the rest of it? You hear that all the time. Where's the rest of it? Because my client will say that there's a lot of good stuff that came after he called you all these horrendous names and said he was going to come take the child. The rule of completeness, in my opinion, applies if it doesn't give the whole story, right? That's kind of what the idea is behind that. If you get enough of the story that there's an understanding what the text message meant, then I don't think the rule of completeness means it's got to be every message. You and I have been texting each other for 3 days. I'm so mad at you. You know, you took my favorite University of Georgia mug when you left me, and I will never forgive you for that. Who cares? So if you get the essence of the message, if the message is relevant, which is something else that matters, and if it aids the judge in making a decision on whatever you're trying to offer it for, then I think it comes in. Then it's up to the other side to say, where's the rest of it? Here's the rest of it.
And who has 75 pages?
Right. And if they have the rest of it, let it all in. Let it all in. That's what I would do. Okay. We're going to now go to...
Aren't we doing the Walmart video here?
Yes. Talk about the Walmart video.
Let's do the Walmart video.
Yes.
Okay, so who wants to take a shot at this? Because all of our parents hang out at Walmart doing things they're not supposed to be doing, right?
This is straight up for wine.
They're not supposed to be in contact with each other in the presence of the child, or they're not supposed to be unsupervised with their child, whatever. It's always Walmart, which I don't go to Walmarts because they frighten me, nothing against the store. Just that's where all our clients are, and they don't like me. So
shop at Target. They don't go to Target.
yes. Now, if they had an observation deck in a bar, I'd be there, but I'm just saying. So how do you we always need the video from Walmart, right? We always need those to get those into trial. How do you get it in? How do you get that into evidence?
Anybody want to take a shot at that? Say again? A little louder. Record systems, Walmart, what? Records custodian at your local Melbourne Walmart.
Yes.
You like Moscato? Okay. Well, we're not done yet. I'll give you both. You get the answer right. Okay. She says records custodian's all she needs to do. What else? You need to what? You need to send a subpoena. Right? Right? Now, how do you get it? Let's say you have it. You got the video. Right? We have the video?
We got the video.
Got the video. Now what? Who are you going to call? Security? Who are you going to call? The store manager? Have you ever been into Walmart and been able to find a store manager? Good luck with that. Anyway, somebody from Walmart.
What about filing a declaration of records custodian if nobody objects, it comes in?
Right? Having the affidavit and I object. Nobody can explain to me because it's so grainy I can't tell what that is. You could do that. You could do that.
Will they stipulate to it? Yes.
We're going to go with no stipulation, though. How do we get it in?
A good idea if the security is a separate company, like a monitoring system, or a representative from that company.
Okay.
You were first.
The possible timestamp differences, but it is timestamped correctly.
Right. Okay.
Would you repeat what she said? Some people didn't hear it, like me.
She said it's good if the security company is a separate security company that has a timestamp and the date and all that sort of stuff on it. It's not actually coming from the Walmart manager. Those videos can be very useful and sometimes entertaining as well.
Yes.
But yes, good point. So whoever can tell you, yes,
Take
this
that
video.
watermelon out of your pants and put it back along with the pack of steaks.
That's right. This video was made at this time, at this store, all that sort of thing. Right?
Sometimes you want to explain the system because some stores have old systems. 7-Eleven. Why should you never work in a 7-Eleven? But what's the indicator? When you walk in a 7-Eleven or any store like that, if they have a height chart at the door, don't work there. There's a reason. They want to know the guy with brown hair was 5'11" when he robbed me. Don't work anywhere there's a height chart. Matter of fact, just stay out of it altogether.
Or
Shop somewhere else.
Or body tape on the floor also.
Yes.
Yeah, not good.
Now, getting the actual video in. Was this video taken on a particular machine that you can describe to us? Yes, it's a 1996 VHS tape. That's why it looks like, whatever it is. Get them to describe what was involved, because as a trier of fact, I want to know why it looks like that. That's terrible. Why does it look like that? With all the technology we have today that you can get for $99 at Home Depot and slap on your front door, it amazes me, these multi-million-dollar corporations, and when I sit in criminal, I'm like, I can't identify that guy. I don't know who that is. That's a guy with a hat. I don't even know what race he is, how tall he is. You can't tell anything. It's so grainy. So get them to identify what's going on.
And make sure you have the court, ASCA, whoever, court administration has the medium that you need to play whatever it is that you need to play for the court.
And do it sometime other than in the middle of trial at 11:15 when everybody's hungry.
I had
Do
a
it
case.
before or during lunch.
I had a case once where I had slides, autopsy slides, and the little tiny things. And I asked court administration for a slide projector. I had the medical examiner as my witness, and they brought me an overhead projector. So I thought, hey, I'm tech challenged. Maybe this is how this works now. I don't know. Maybe it's a new thing. So trying to make the slide work on the overhead, I put it in the little slot. Well, the slot was the handle for the thing. So it ate my slide, so then I had to tip it upside, I don't know what I did here. I had to tip it upside down and to get my slide out. But anyway, you put a slide on an overhead projector, guess what it looks like on the wall? Same thing, it's this big. So yes, make sure that you have what you need before you try to present something. Yes?
Sometimes our police officers share.
You're gonna do excited utterance.
Have videos. Can you put them on the stand? If they were the one that asked the security company or the manager for the video, and they viewed the video, and they copied it to a thumb drive, and then made us a copy, can you go through the chain of custody with them and have them say it accurately reflects the statement I took from the witness, or something of that nature?
What does everybody think? You have law enforcement, they have the video from 7-Eleven, and they have a VCR player, so they can bring it in.
Is chain of
can you
custody
use
as
them?
important
Yes.
in a civil case as it is in a criminal case? No. That's the first thing. So really, it can go through 57 hands as long as it still accurately depicts what was recorded. So you really don't, you can go through the chain of custody, but you don't have to. It's really the two questions, fairly and accurately, and how do you know? Really, that's it.
Yep. And that's important too, because you're going to get those objections with pictures. They're going to say, he didn't take the picture. It doesn't matter. Whoever can testify that it accurately reflects the situation you're trying to memorialize in that picture, then that's all it takes.
I'll give you an example. Zillow. Anybody use Zillow, right? Zillow, if you sell your house for months and months after that, it shows all the pictures of the inside of your house that the whole world can see, which is weird in and of itself. But there's usually an overhead, bird's eye view, I think, on Google Maps. And there's usually a front door. And on the front door, you know, you can go see what the house is across the street. Oh, the Munsters, I don't want to live here. So I had a case where the Google car, you've seen the thing that drives around with the spinner on the top? That's what they're doing. They're taking pictures of everything driving through your neighborhood. They made the presentation that this was a place where drugs were interchanged routinely, aka a crack house, and one of the indicators was the 7 or 8 cars that were lined up driving in through the drive-thru like it was McDonald's. They used the Google map picture because when that Google truck drove by, they were obviously in the middle of a sale. And there were 5 or 6 cars. There's like 15 people on the porch. And I mean, people's hands are out like this. It was the craziest thing ever. And it was a clear picture. Did they have to say who took the picture? Did they have to bring them as a witness? None of that. Is this a fair and accurate representation of the crack house? Yes. How do you know? Because I was across the street last week and it looked just like that. So it doesn't really matter who took the picture.
So when you have an audio tape, a video tape, they still say those words, DVD, CD, whatever you have, do you publish or not publish to the court? Anyone? Bueller? So do you play it for the court, or do you just give it to the court and anticipate and hope and plead that the court listens to it or watches it on their own
And you
time?
have to give an answer for why.
Yes.
I say you have them watch it because you want it on the transcript.
Have them watch it because you want it on the transcript. That's right. It'll be
Very good
typed
point.
out. Very good. Be typed. And hey, I'm walking back here to give you something. I got nothing in my hand. Okay. It'll be typed out. What's another reason? How about the idea that the judge can see the reaction of the parents?
Right?
Right?
Right? And that whole thing about demeanor and everything. And some judges don't want you to publish it, right? And then you say, look, whatever happens, it's TPR. Whatever happens, there's going to be an appeal. So this way it's on the transcript. It's in the
Good
record,
answer.
right? Because otherwise, then you have to do a supplemental
You have earned
record, get
something
it
for
set
your
up.
whole row. Pass those down.
Okay.
Oh,
Now,
would you do the excited utterance and I'll be the witness? Let's first talk about excited utterance. When would you even need to do this? When is this? Anybody think of a time where? Yes, ma'am. Heat of the moment.
When something happens and they go, oh crap.
Yeah. You got me. What else? Anybody have any examples of when it's happened to you? Children. There you go. All the time. Dang, Mom. What the heck? Anybody else? Great answer. What are the questions to ask to get an excited utterance in?
When you were present with Mr. X, did he make any statements that were not in response to questions?
He did. He blurted a lot.
What was Mr. X's emotional state at the time?
He looked like the Scarecrow in the Wizard of Oz. He was crazy.
So, based on that, would you say that he appeared excited?
Absolutely. He was beside himself.
Judge had no additional questions.
Thank you.
very good.
And then-
You let it in?
Let it in, right? You let that in?
Absolutely.
And then
Any
you
objections?
tell him, well, what did he say after that? I probably left that off there, didn't I? Probably, I should have put that in there. What did he say? He said that when his mom walked, well, anyway, I won't get into that.
How about your clients excited? We won't get that either. I had a client one time, she had a DUI. I was representing her in the dependency case, not the criminal case, fortunately. But, so they had a video of her doing the walking and talking, and the sobriety field test. And she said, and I know it's a bad joke, but she said it, Jesus, I couldn't even do this sober. So, yeah. Excited utterance, maybe. Yeah, so, okay, so now you have your whatever before the court. How do you get medical records in? Anybody? How do you get medical records into evidence?
What's the easiest way for medical records?
Affidavit of records custodian. Who said that? Okay. Now you give them, you make a copy for the other side, right? And you give them to the court and all that sort of thing. And then what happens with them? What do you do? What do you do with them, if anything? Have them admitted into evidence, right? I can tell you I've seen a lot of people do this at trial, and I've read transcripts from all over the state. A lot of times they get, they're stacks like this of medical records. Nobody does anything with them. They've reviewed them, they've highlighted them, they've written notes on them, but they never talk about them. I mean, that should be part of your closing argument, right? That should be part of what you're talking about to the court. The medical record reflects 3 broken bones, or mom's blood alcohol level, or whatever. So just remember that when you get medical records in, you're all excited because you got them in, and then you forget about them. Some of you just don't do anything with them. It's critical. There's a lot of really good information in those too. If you can read, the nurse's writing is the worst. My nephew's a nurse now, and I told him I'm sending him to handwriting school because sometimes those records are really hard to read, but there's really good information. Just don't forget about it. Make sure you synopsize them in some way for the court to point out what you think is important in those records. There's a reason you wanted the court to have them. Trust me, the court's not back there reading them. And they're not going to go up to the DCA either unless you specifically request that they go up to the DCA. So make sure that you've done some sort of synopsis on those.
I just want to apologize for that whole roll when you put my butt in your face.
All right. Impeachment. Yes.
Who can you impeach?
Woo.
Everybody. I just want everybody to answer. And why would you want to impeach your own witness? That seems really weird. Anybody got an example of needing to impeach your own witness? Wait, let me bring you the microphone. Hold on. Because she's already mad at me for not bringing the microphone. Why would you impeach your own witness? Give us an example.
If you called a parent and they were saying something that was different than what you knew to be the fact.
Isn't it true that usually means you're going to correct somebody you're talking to, right? Any other examples? Any specific examples of impeaching a witness? Yes?
I've had a witness change their story from all the other prior testimony that they provided in depo and so on, and then on the stand all of a sudden it's a perfect world.
That's exactly right.
No, witnesses don't change their stories.
Well, I've had a child that she didn't recant the sexual abuse, but she didn't want to talk about it, but she had written a letter that she signed. So we presented the child with the evidence about the abuse and just asked her if that was her signature.
Okay. It's tricky with a child witness too. And for child witnesses, their out-of-court statements, so their child hearsay statements, come in as substantive, even if they say something different on the stand. So you can impeach them. It's kind of hard. You're kind of beating up a kid. It's tricky. It's tricky is all I'm saying. You can do it, but their out-of-court statements come in as substantive anyway.
Let's say I want to impeach your credibility. Those of you that have done criminal law, what's the first thing I'm going to do if the defendant takes the stand? Convictions. How many convictions? For what? Felonies. Very good. Or as I like to say, because I'm old school, because it sounds dramatic, crimes of moral turpitude. Doesn't that sound tough? Oh my God, what did he do? So, when you have someone on the stand in a civil case, can I ask them, during the 3 years that this case has been in court, how many times have you been arrested? Objection, that's not a conviction. Who cares? Can I ask them that? And if so, why? So if I'm asking you why, then I can probably ask them that, right? Does it come in? How many times you been arrested in the last 12 months?
Are you
Anybody?
asking?
Does it come in? Yes. Why does it come in? Because we're trying to impeach them in this case? No. Why? Can't take care of your kid if you've been in jail, right? Isn't that what we want to know? Wow, you've been a great parent. In the last 3 years, you've been in jail 24 months, but right here, with those crocodile tears, you loving up on everybody, aren't you? It's okay to ask the question. I promise you, you will get an objection. What's your response? I'm offering it to show they're unavailable to parent. That's all you got to say. And that comes in. Has anybody had that kept out? Raise your hand if someone won't let you do that. Ooh, bad judge. Don't tell me who it was, though. I don't know. You had it kept out, and then 5 minutes later, the other attorney got it in?
No, we didn't. They never got it.
Oh. Is it, well, what do you have to prove? It's relevant, right? Is it relevant? Yes, ma'am. It's absolutely relevant.
Just a few years ago, we were having a problem getting those questions in, so instead we did a timeline on a flip chart and said, January 2017, where were you? In jail. February 2000, and went through the 3 years, and that's how we got it in. We just showed how many months they'd been in jail instead of that question that was objectionable. It just wasn't worth it.
Awesome.
It's interesting because a
Same
lot of
information,
times,
though.
Well, that's
Yeah.
great because it had a timeline. The judge, it showed in the last, whatever it was, 36 months, there was like only 2 months that there was no X.
In the video age, even judges who are over 50 like visual presentations, right?
well, and it's interesting because the parent's attorney will object when you ask, how many times have you been arrested or been in jail, and objection, that's not a conviction, blah, blah, blah. They put their own client on the stand and say, how come you couldn't visit? Because I was in jail. Oh, now it's relevant. I always used to tell my clients, if the department's getting ready to file a TPR, I would tell them, go clear up your warrants or whatever, get incarcerated, because it terrifies the department. They don't like to do a termination of parental rights on somebody who's incarcerated. It's just kind of a little bit more mucked up than people who are not incarcerated, right? So I would always make the argument, well, at least they have stable housing. So.
All right, we talked about this. We've only got a few minutes left. Never, ever, ever waive opening. Never, ever, ever waive closing. Anybody know the rule of 3? Anybody had a speech class, or what's the rule of 3? Okay. What was yours?
Tell them what you're going to tell them, and then tell them what you've told them.
And why? Takes some of us, are you looking at me when you say that? You probably are. It takes some of us 3 times. I will tell you this. Opening statement, I write down every single word every lawyer says as fast as I can on opening statement. And then what am I looking at during the presentation? That same sheet of paper. And what am I doing with it? Did they exaggerate? Did they get it right? Did they prove this? Did they prove that? Because we have to make findings. You've got all this stuff you've thrown against the wall. You're hoping it all sticks. Sometimes it sticks, sometimes it doesn't. But we have to point out what does stick. So when you get to closing, what am I looking at? Same thing, right? Did they prove those things? So unless you've amended something along the way, I'm still looking at your opening statement, seeing if you did that when you said it in opening. I'm looking at it again when you make your presentation, and I'm looking at it again when you do your closing. Be sure you quote the statute. The reason you quote the statute is just like Kelly said a minute ago, that's also in the record. It's also in the record. Don't just say fail case plan. Quote the statute every single time you get a chance. What do we have left in 2 minutes we want to talk?
Professionalism, of course, this is critical to all of us. It's really important. You can only lose your credibility one time, right? Once you've lost it, the judges know, and the judges talk to each other. and make hand signals occasionally. So judges talk. If you lose your credibility with one judge, all the other judges are going to know that you're not to be trusted or whatever the issue is. Whenever you're in court, please ask to approach the court, the witness, the clerk.
So in my courtroom, standing order. May I approach? Yes, standing order. Please, God, don't ask me to approach the podium because you're going to stand at the microphone and ask somebody a question. It takes, seriously, if you do a 3-day trial and someone asks, may I approach the podium to cross-examine the witness? Think about that. May I approach the witness? May I approach the court? No, just do it. Just do it. So, approach whatever you want to approach, just do it. Seriously though, most judges will tell you, and I'm being facetious, I'm not that, am I? I'm not that eat up about it. I usually say standing order, approach anybody you want. Do whatever you need to do to get your presentation. So don't be too eat up about that, but there are some judges, and I won't say who, because most of them are retired, thank goodness. If you don't say it, counselor, where you think you're going? You know, I've had it happen to me. Mike, I was going to talk to the microphone in the podium, and they're like, no, you got to ask. There's one judge, how do I say this without saying his name? Anyway, he said he was, at one point, he couldn't hear. The poor man just, I shouldn't do this. Ask me afterwards. Anyway, he said his name, he said he was related to a Civil War hero. And I said, I think you meant Deaf Davis. Under my breath, like this. I think he meant Deaf Davis. He heard that. He didn't hear a dang thing I said for 3 days. I heard that. He heard me say that. And God bless him. I love him to death. He's a great jurist. The one thing he heard in 3 days was me mocking him. So that was bad.
So, there used to be a clerk in a certain circuit that you could not approach that clerk for any reason whatsoever. And the judge would tell you, do not even walk toward my clerk. Don't even look at her. So you're like, I need things marked. I don't know what to do. So make sure you know the local practice. One point we wanted to really make here is don't argue your point after a ruling. Make sure you've made your record, but ask the court if you can proffer. If you have something you want to get before the court and the court rules against you, judge, may I make a proffer? And that usually they say yes, and you can do that. So that's still on the record. And please, please, please be realistic when you're telling the judge how long your trial is going to take. You have an egregious abuse TPR with 726 expert witnesses. You're not going to get it done in a day. It is not going to happen. The judge knows it, and you know it, and everybody else knows it. So be realistic. Also, don't ask for 8 hours if you know you only need 3, just so you can take the rest of the day off.
Last comment I want to make, and then we're done. We're going to finish right on time. Anybody have a judge that will try a case an hour here, an hour there, over a 6-month period? Anybody think that's a good idea? No. Ridiculous. It's ridiculous. Nobody, including you, remember half of what happened 6 months ago. We don't do that, do we? We don't do that. Now, for those of you who really know fine wine, this ain't it. I have the last one. If someone could tell me, you got to raise your hand, you can't blurt it out. Who is the best team in Major League Baseball right now? Who's got the best record? I saw you first.
Oh, I didn't hear the record.
Oh. Saw you second. Who? No. 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 No.
Yankees.
Oh, who said Astros? You win. There you go. We have a few of the laminated versions. Anybody who gets them first can have them. The printout versions will be on the website. There's tons of candy up here. We're glad you came. God bless you. See you outside. If you have any questions, come find us.